Members of the Senate are focusing on gun rights.
Major ruling involving the Second Amendment.
It's a case that legal experts will be watching closely.
October 2025, a month that could rewrite the future of gun ownership in America. The Supreme Court has just taken on a case that could decide whether your concealed carry permit means freedom or nothing at all. Millions of Americans who celebrated the 2022 Bruin victory are now asking, did we really win anything? Because today, you can pass every background check, pay every fee, take every course, and still be banned from carrying where it actually matters. Stores, restaurants, churches, or parking lots. And the states doing this? They claim they're following the law while quietly making your rights disappear in practice. That's why this new case, Woolford versus Lopez, could become the most important Second Amendment showdown since Bruin itself. Chapter 1. The case that could break the system. On October 3, 2025, the Supreme Court agreed to hear Woolford versus Lopez, a case out of Hawaii challenging what gun owners call the vampire law. Because just like vampires, your right to carry can't enter private property without an explicit invitation. Under this law, even with a valid permit, you can't walk into a store, restaurant, or even a church unless the owner puts up a sign saying guns are welcome. And let's be honest, how many will? They don't want the headlines or the backlash. So your permit becomes nothing more than plastic in your wallet. Chapter 2. The circuit split that forced the court's hand. Two men, Andrew Woolford and Jared Pohl, sued Hawaii saying this law violates the Second Amendment. The Ninth Circuit sided against them. Meanwhile, the Second Circuit in New York struck down an almost identical law. Two opposite rulings on the same issue. That's a circuit split, and that's when the Supreme Court must step in. Arguments begin late 2025 or early 2026. A ruling by summer 2026 could decide whether the right to carry is real or just theoretical. Even the Trump administration has weighed in, urging the court to hear the case. Their filing points out that 5 states, representing over 60 million Americans, have similar laws on the books. This isn't about Hawaii. This is about whether states can pretend to respect your rights while stripping them away in practice.
Chapter 3. How We Got Here, the 2022 Bruin Decision. To understand this battle, we need to go back to 2022, New York State Rifle and Pistol Association versus Bruin. That ruling was supposed to change everything. Before Bruin, states like New York, California, and Hawaii used may-issue systems, meaning bureaucrats decided who deserved self-defense. Ordinary citizens? Denied. Celebrities and politicians? Approved. But Justice Clarence Thomas shattered that system with a single line. The Second Amendment protects the right to carry a handgun for self-defense outside the home. He introduced the text, history, and tradition test, meaning no law restricting your rights can stand unless it's rooted in the founding era. It was a historic win for gun owners, but the celebration didn't last long. Chapter 4. The States Strike Back. Within weeks, anti-gun states began fighting back. New York passed the Concealed Carry Improvement Act, banning carry in nearly every sensitive place imaginable: parks, churches, restaurants, stadiums, public transit, even Times Square. Then came the private property default ban: no guns on any property unless the owner explicitly says yes. Other states followed: California, Hawaii, New Jersey, Massachusetts, all with one goal: make your permit worthless. Chapter 5. The Legal Chaos. The moment Bruin dropped in 2022, gun owners thought the war was over. But 3 years later, it's clear that was only the first battle. Because the anti-gun states didn't surrender, they regrouped. They studied the decision line by line and figured out how to obey it in words but violate it in practice. And the result? Legal chaos across the country. Some courts are standing tall, enforcing the text, history, and tradition test the way Justice Thomas intended. Others are twisting it into knots, trying to protect the same bans that Bruin was supposed to end. In Mississippi, a federal judge went so far as to strike down the federal machine gun ban, arguing the government couldn't prove a historical basis for outlawing a weapon that millions of Americans legally owned and used. The ruling shook Washington. It was proof that Bruin could cut deeper than anyone imagined. But in California, another court upheld the 10-round magazine limit, claiming that magazines weren't arms at all, but accessories. As if a rifle without ammunition somehow fulfills the Second Amendment. It was the kind of circular reasoning that leaves millions of law-abiding gun owners trapped between contradictory laws, depending on nothing more than what state line they happen to cross. And while those cases fight their way upward, state legislatures keep writing new ones, each slightly different, each daring the Supreme Court to strike them down. It's a never-ending chess game, the Constitution versus the bureaucracy. And at the center of that chaos sits Woolford versus Lopez, a single case that could bring the whole fight back under one rule, one clear interpretation that no state can make your rights disappear behind clever language or hidden restrictions.
Chapter 6. What's really at stake? If the Supreme Court sides with Hawaii, it will set a devastating precedent. It will tell every anti-gun governor in America, go ahead, you can follow the law and still crush the right to carry. Because on paper, Hawaii complies with Bruin, but in practice, it kills it. Imagine this. You pass every test, you pay the fees, you wait months for approval, only to discover that your permit is valid everywhere you don't go. It's a right that exists in theory, but vanishes in reality. If the court blesses that model, the Second Amendment becomes a hollow echo, a promise with no power behind it. And once that happens, it won't stop with Hawaii. California will tighten the noose. New York will expand its sensitive places. New Jersey, Maryland, and Massachusetts will follow suit, until the right to carry is nothing more than a talking point. But if the court rules the other way, if it strikes down Hawaii's law and restores the meaning of Bruin, it could change everything. It would send a message that cuts across every courtroom and state house in America. You can't rewrite a right. It would force states to honor permits that actually mean something. It would remind bureaucrats that may issue by another name is still unconstitutional. And maybe for the first time since 2022, the Second Amendment would stand not just as a line in history books, but as a living, enforceable right for millions of ordinary Americans. Because that's what's really on the line here. Not politics, not partisanship, but the simple question every American should be asking. Does my government trust me to defend myself?
Chapter 7. What you can do now. So, where does this leave you? If you live in one of the 25 constitutional carry states, it might be easy to shrug this off. But here's the truth. Freedom doesn't vanish all at once. It fades, one law at a time, one loophole at a time, until one day your rights are gone before you even realize they were slipping away. If restrictive states win this battle, your state could be next, because once a blueprint exists for lawful restriction, others will copy it. If you live in places like California, New York, New Jersey, Hawaii, Maryland, or Massachusetts, you're already in the storm. Your rights exist in legal limbo, granted on paper, denied in practice. You can get a permit, but it costs hundreds of dollars, hours of training, interviews, character references, and even social media checks. And once you finally have it, you'll need a map just to figure out where you're legally allowed to stand. So, here's what you do. 1. Know your rights. The Bruin decision is your foundation. You no longer need to prove a special reason. If you meet the objective requirements, you're entitled to a permit. That's the law. Hold them to it. 2. Stay informed. Gun laws are changing faster than ever. What's true today may be overturned in 6 months. Don't let misinformation become your silence. 3. Document everything. If you're denied, delayed, or discriminated against, keep records. Those denials could become the evidence that wins the next court battle. 4. Support the fighters. The organizations challenging these laws, they're not faceless groups. They're lawyers, veterans, parents, and everyday citizens putting their time and money on the line for your freedom. Join them, share their work, fund their cases if you can. Because this fight isn't theoretical. It's real. It's happening now. And its outcome will decide whether your children inherit a right or a permission slip.
If you believe the Second Amendment wasn't written for convenience, but for courage, hit that like button. Share this video with every gun owner you know and subscribe so you never miss an update. Because history isn't written by the loudest voices. It's written by those who stay vigilant.